record and get started. It's a few minutes after 3. Good afternoon. This is a pre-hearing conference in docket 8613, an investigation pursuant to 30 VSA sections 30 and 209 into sound levels from the Georgia Mountain Community Wind LLC wind electric generation facility in Georgia, Vermont. My name is John Cotter. I have been appointed hearing officer for this proceeding, and with me today is a board staffer, Andrew Pugh. Before we get started, I want to emphasize the limited nature of this proceeding. The proceeding is limited to the subject matter of the complaint that was filed by Mr. and Mrs. McLean on September 18th, 2015, and what, if anything, Georgia Mountain Community Wind, who I'll just refer to as GMCW going forward, must do in response to the complaint. This proceeding will not address any issues that were raised by the McLeans in a subsequent filing that I believe they entitled motion for relief. That is something that the board is going to take up separately and consider whether to take action or not. I know that there's still some deadlines for filings and so forth. So this proceeding is actually pretty limited in nature, so I just want people to keep that in mind as we move forward. So, that said, if we could start out by taking appearances, starting with the department.
Aaron Kosicki on behalf of the Department of Public Service.
Representative Mariana Gamache. I am a sitting member of the Energy Committee.
Okay.
Scott McLean.
Melanie McLean.
Andy Rodvogel with Duncan Saunders, representing petitioner Georgia Mountain Community Wind. With me today is Sash Lewis, a colleague of mine, David Blittersdorf, and Marcus Vasquez with petitioner.
Mr. and Mrs. McLean, is it your intention to act as parties in this proceeding? Or are you just sort of interested in keeping track of what's going on? I mean, if you did file a complaint which led to this investigation, when the board issued its order opening the investigation, there was a footnote that explained that.
Well, we were interveners in the original, docket when they were applying for the CPG.
Right. This is a different docket. This is not about their CPG.
No, I understand that.
So it's a different docket. So if you do want to be parties, you need to ask to intervene. And I just wanted to get clear for we have the department is automatically a party, and GMCW is automatically a party.
But by default, we're not parties because we're the affected parties, I guess.
We're the ones that complain, so we're not parties.
No, statutorily you're not parties, and I know it's.
But we get the invitation to come down to the.
We absolutely wanted to invite you to come down. We wanted you to know that the board did open an investigation, of course. So I mean, the question is pretty simple. Is it your desire to be parties in this proceeding?
Yeah, I mean, we want to know what's going on. Obviously, it affects us on a not daily basis, but we're affected quite regularly by the, so we want to see how these things are going to settle out and going forward.
Right.
And
right.
try to smooth out the whole process and
Yeah. Well, as I said, this is.
No, I understand that. I understand. This is just related to the one incident, but
yes.
but of course, it could have far-reaching ramifications, going down the road. So yes, we're interested.
Okay. Now, the reason I'm asking you is because you could be an interested person and receive copies of things and keep track of the docket. But if you wanted to actively participate, for example, and advance a position as a party, then you have to ask to intervene, and then you'd be subject to things like, depending upon how complex or not this proceeding gets, then you may have to answer discovery questions, for example, if we develop a test schedule that required pre-file testimony, just things like that, which I'm sure you're familiar with from the other docket.
Right.
So, all right. Well, without having to get too formal here, the McLeans have asked for party status. Do either the department or Georgia Mountain Community Wind have an objection?
We have no objection.
The Department has no objection.
Then I'll just take it as an oral motion and rule from the bench that a motion to intervene on a permissive basis for the McLeans is granted.
Very nice.
Okay. had a couple questions for the department in GMCW, but Mr. and Mrs. McLean, please feel free to chime in on these. I was curious, I'll just say have the parties instead of the department or GMCW, had any discussions about how this investigation should proceed?
We had.
Okay. Did you, that include the McLeans in those discussions?
No, it was just Georgia Mountain and the department.
Okay.
And we had not received any sort of motion from the McLeans.
Right.
More than happy to have a discussion with the McLeans.
Well, why don't you go ahead and, to the extent you can, describe the discussion and any recommendations that you may have agreed upon.
Sure. So Georgia Mountain Community Wind and the department had preliminary discussions, trying to scope out what the next steps might be in response to the board opening this investigation. We both looked at the order opening the investigation, and we thought that there might need to be an interim ruling from the board on one particular issue, most notably. I would hope that the filings that both the department and Georgia Mountain Community Wind filed in response to the McLean's complaint, the department, Georgia Mountain Community Wind filed responses on October 9th and November 2nd. The department filed its response on October 16th. I would hope that those comments make clear that Georgia Mountain Community Wind and the department, I think it's safe to characterize it as we have a fundamental disagreement about what, if any, next steps the sound monitoring protocol, or more specifically the complaint resolution protocol within the sound monitoring protocol, requires Georgia Mountain to do, given the information that's been presented to the board in the hearing out to this juncture. I think it's also fair, please correct me if I'm wrong, I think it's fair to characterize the department's position that the complaint resolution protocol requires Georgia Mountain to engage, to offer attenuation monitoring at the McLean residence in response to the complaint that's been filed. And Georgia Mountain's position is that is not the case. And more to the point, there has already been extensive monitoring at that location, and the monitoring protocol outlines that there doesn't need to be additional monitoring of the site for a period of 5 years. I think we need resolution to that question before we can sort of figure out how to fashion next steps going forward. If the hearing officer feels that he can get sufficient information before him right now to resolve the question of whether or not the sound monitoring protocol requires any, what if any additional steps in the protocol, we'd like the board to rule on that. On the other hand, if the board would like additional briefing on that issue from the parties, including the McLeans, to outline what the monitoring protocol requires, you have the information that they have in front of the board at this point, I'd be happy to do that. But I think it's a critical first step in sort of figuring out how to shape the remainder of the schedule once we have an answer to that question.
Mr. Ralph?
I think that's a fair summary, and I won't repeat everything, but let me just distill our view. Looking at the board's order, we were left somewhat perplexed about exactly what this proceeding was going to look at, because it appeared to us that from the back and forth that the board received the complaint, our response, the department's response, our reply, that the issue that was being engaged was not so much whether the project was actually not in compliance with the noise limit, that it was a lot of discussion about what does the sound protocol actually require to determine that issue. We presented our view, the department presented its view, the board didn't resolve that, but simply opened the investigation. And we agree with, I think at this point, we don't see a way to really go forward and get to the crux of the issue that you've articulated in the board's order, which is, the board's order states, the board is initiating an investigation to determine whether operation of the project resulted in sound levels at the McLean residence on the evening and night of September 18, 2015, in excess of the applicable limits. That's sort of a retrospective look at what happened on that particular evening. It's not a prospective, or do you remain in compliance, are you in compliance on an ongoing basis. We've given the board what we thought was all the relevant information to make that determination. The department disagreed with our interpretation of the protocol. So to really proceed, I think we need that interim ruling, which would then inform the parties about what further evidence, if any, they would proffer.
Okay, and then I guess, Mike, and I'm going to turn to you in just a second, Mr. and Mrs. McLean. I heard Mr. Kosicki at least seem to suggest that as far as the department was concerned, the department didn't feel the need to make any additional filing on this interim question, and that they were happy to rely upon what they filed already unless the board wanted something more. Is that an accurate description of where Georgia Mountain Community One stands?
I think it is. I think we've explored the issue to the same degree the department has, same level of detail, and I think that if you were prepared to look at those and make a ruling or ask for additional briefing, we're prepared to accept that.
Yes, I mean, having read the materials that are submitted so far, I believe that I have enough information to make a ruling. As I tried to craft that, if I felt I needed additional information, I could certainly issue a written request for that. So, Mr. and Mrs. McLean, having heard what you've heard, and I think you've received copies of all of these findings, yes?
I'm sorry, what was the answer?
Yes, we have.
Yes, you have to actually say your response.
Oh, right.
So there's no way to type it on and the records.
All right.
That's okay. I do it as well. Would you two like an opportunity to file something in writing? You've already your interpretation of what's required under the complaint resolution protocol and a recommendation on how I should rule on this?
I don't think so.
I'd like to make some statements, a statement now regarding the whole thing. My thought on it, I think it's relevant. We filed the complaint. Georgia Mountain's response was yes on the night in question. We were running at or near full capacity. We were in compliance. Nothing else required. Then the board came, the department came back with, geez, we want more information. And my feeling is that, the bottom line is there are issues when they're running at full capacity. Georgia Mountain will look back at the post-construction monitoring and they'll say, okay, out of, and I'm going by memory here, 21 or 2,200 hours of post-construction monitoring during the 4 seasons, we were never out of compliance once. They ran at full capacity during that time 5 hours. That's 0.2% of the time. There are so many variables that affect sound attenuation, that I don't believe a sample size of 0.2% is an adequate database to be able to look back and say, well, geez, we were running at full capacity. We have historically run at full capacity and not exceeded the limit.
No, I understand your concerns, but I'm a little concerned that we may be straying beyond.
No, I'm just saying that I agree with the department's,
Okay.
Requesting additional information. I don't think we can just say that they were in compliance that night, because historically they have been when they're running at full capacity. So I think there's something that needs to be done further.
Okay, that sounds like you're in agreement with the department.
Yes.
Yes, okay. Well, as I said, yes.
And just so you know, it's just because we just complained that night doesn't mean that's the only night that we can't sleep because of the noise.
I understand, but the board received a complaint about a specific night and asked for.
Right, but we're
for
talking like
compliance.
in retrospect. Well, it's not just in retrospect, it's tomorrow and the day after and the day after and the last 2 months since we complained. So what we don't want is for this to drag out a long, big, long schedule, and us to drive up here in Montpelier, take time off from work, not be able to sleep when it's loud. We don't want that kind of schedule.
No, and I understand this, okay, what I tried to explain, that the board opened this proceeding to determine whether or not the project was in compliance on September 18th, 2015. That's the limited nature of this docket, and I can't just expand it beyond that. You know, that's what it was noticed as, and if we started trying to make it about something more generic than that, then that would be inappropriate, because people would not be prepared for that. As I mentioned earlier, I know you filed the, I believe it was called a motion for relief in docket 7508, and the board is awaiting responses from GMCW and then eventually the department. I don't know what the board will do in response to all that information once it gets it, other than I know the board members will go over it very carefully and have a detailed discussion about whether or not to open the proceeding. Whether they will, I can't tell you at this time. And I'm sorry if that's not satisfactory to you.
I mean, it's,
It hasn't been for 3 years.
The limit, as I said, this is a very limited proceeding. It's what it was used for.
no, it's a start. I mean, that's, we gotta start someplace,
And
so.
we're more than happy to have you as parties, nobody objected, so.
Yep.
Then I will, I guess, get to work on issuing what we refer to as the interim ruling, and that should help everybody make a decision about what sort of schedule would be useful going forward.
May I ask, just on that point, the department's filing raised 2 or 3 actually distinct issues about the interpretation, about what they were asking for additional investigations or modeling, and vis-a-vis the sound protocol. Do you feel like you need to have those distilled for you as discrete questions to be answered? Because I do think that there are, I think, at least 3 different questions that are before you, and I can articulate what I think those are.
Sure, go ahead.
The department asked for some additional modeling to be done to compare the conditions that occurred at that evening with some other data. I think there's a question there about whether the sound protocol would require that additional aspect of the investigation. Secondly, the question of whether the sound protocol in Section 8 states, the interpretation of the provision which states that if sound monitoring has been done, it doesn't get repeated within 5 years. And the third and related condition is the whether an indoor-outdoor test needs to be offered to the McLeans under the circumstances of the protocol. So I think there are three different issues.
Yes, I actually would agree with you that those are 3 issues that need to be addressed, absolutely. So, let's see if there's anything else I wanted to cover. Okay, that's really all I needed to cover today. Did the parties have anything else?
If it might be helpful, Mr. Conrad, would it be helpful to schedule a status conference? Sort of have something in place, start thinking about fashioning a schedule after the interim ruling? I think to discuss that now, I'm just trying to think how to efficiently move this.
I think probably the best way to approach that would be when the interim, well, first I'll have to put out a pre-hearing conference memorandum, but that shouldn't take long at all. Just memorialize what we talked about here today, and then I would move as quickly as I could on the interim ruling, and at the time that it issues, have the clerk's office contact the parties about a status conference. If that makes sense to everybody. And also because if we do get around to the point where the parties are filing things in paper, because it's a hearing officer case, you only need to file an original in 3 copies, not the higher number of copies if it's a paper case. Okay? All right, folks, we're adjourned for the day. Thank you for coming down. Thank you.
spell your last name?
MC, capital L.